Hi, everybody. Jean Humbrecht here with Humbrecht Law, criminal and traffic defense attorney in Manassas, Virginia. Welcome to the next webinar in our series, Planning for the Future. Today, we have a very special guest, Michael Wakefield from Wakefield Law. He's going to be talking to us about something that we probably don't want to talk about, but really need to. Estate planning documents, end of life documents, something that everybody always, I would think, should be thinking about and considering when they're talking about their overall financial plan, because the financial plan is not just for the rest of your life, it is to take care of everybody else when you are no longer here. So with that, I didn't know what else to say. I'm going to turn it over to Michael. Michael, if you tell everybody just a little bit about yourself and what you do, and then we'll get into the presentation.
Absolutely, yes, and thank you for having me on, Jean. So, my name is Michael Wakefield. Our firm, Wakefield Law. My father started it, I think, 30 years ago or more, and it's a small family-run firm in Leesburg, but we really serve all of Northern Virginia in a couple different areas. But one of my specialties has always been estate planning and all the related things with that. But just about me personally, my wife and I live in Percival with our new daughter. She's just, she's one of those that born right when this whole situation started back in March. We've got our dog and we really love it out there. But so really for me, estate planning, to go sort of right into it, estate planning, the whole purpose is to do two things. One, it's to avoid conflict after you're gone or after something happens to you. And the second is to make sure that all of the things that you've accumulated over the course of your life, the right thing happens to them, either again in the eventuality of your incapacity or you're passing away. And none of these things are things that people want to talk about, but they are important to plan on. And I always say, you'll make your plan and then you can forget about it and go back to living your life. It's stuff that needs to be thought about really carefully, especially in these times. But so basically the way I do estate planning, and I told Jean, I'll do this sort of in a way that any client that would, or prospective client would come to me, I'll explain sort of, the subject of this webinar. Do I need a will? Level one, just really basic estate planning, whether you're 18 years old or whether you're 120 years old. It includes a will, a power of attorney, an advanced medical directive, and a few other related documents that are important documents to have, just again, for anybody at any age with any sort of asset landscape. One of the biggest misconceptions about estate planning is that only the rich or only the elderly need to focus on it. Really, if you're somebody who doesn't have a lot of assets accumulated, those people in that situation often feel really strongly about what happens to them if they're incapacitated, in a coma, or what happens to their, to get sort of grisly with it, what happens to their remains. Your basic level estate planning, to just sort of go through it. Everybody's heard of the will, but just to cover it briefly, the will does three main things. It designates an agent to make decisions. That's your executor or your personal representative. The second thing a will does is it disposes of your property. It says this goes to this person, this goes to this institution, and the like. And the last thing it does is it deals with guardianship for children. It does several other things, but those are the big three. And often the guardianship for children is one of the most important issues and one of the biggest issues that causes an individual or a couple to start thinking about the estate planning process. To move on, the power of attorney, again, lots of people have heard of it. Really what it does is it designates a financial agent to make decisions for you while you're still living. I always like to focus on some of the misconceptions, some of the frequently asked questions that I get. Some people will come to me and they'll say, for example, my father passed away, but I have his power of attorney, don't worry. And I'll say, no, that's, of course, that's not how powers of attorney work. They only are effective while the person who created the power of attorney is living. The classic example is when you're in a coma, for example. It designates an agent to make your financial decisions, to help run your business, to pay your mortgage, take care of your financial life. And the other side of that coin is the third document in basic estate planning, which is the advanced medical directive. This one designates an agent to make medical decisions for you, obviously, of course, while you're still living. And, it sets out your wishes. For example, under these circumstances, I do want life-prolonging measures to be taken. Under these circumstances, I don't. I want to be able to pass away with pain management and things like that. So it allows you to have your voice heard. It answers the question that everybody hears a lot in these situations, which is, what would they have wanted? So like I said, I try to pack as much value into basic estate planning as possible. I also include a standalone HIPAA waiver for clients of mine, which designates people who can access their medical records and meet with your medical team about your treatment and that stuff. The reason this is a really important document is for all of the institutions that a client will see, they sign an individual contract with that institution that says this person or these people can access my medical records. And it could look different, based on what time of your life you went to different institutions. So this document, the HIPAA waiver, supersedes all of those other ones, and it says these people can access medical records. Another document I included in basic planning that's really important is your final disposition. Basically what you would want to happen with your burial services, with where you want your remains kept, all that sort of stuff. And sometimes people are very scant and they say, this is my agent who's going to take custody of my remains, that's it. And sometimes people have a lot of thoughts that they want to include, and we can make it as personalized as a client wants. So like I said at the beginning, the whole reason you're doing these documents is to avoid conflict. And it leads me to another frequently asked question, which is about probate. So when somebody passes away, the decision maker, if there is a will, the decision maker designated in the will takes the will to the court and starts the probate process. If there's no will, there's still functions in place to designate a personal representative for the estate. But the more common example, if somebody has a will, they go through the probate process. That's where debts of the estate are paid, where if there is a will, the decision maker designated takes the will to the court. Then the disposition of the assets happens, and guardianship for children, that kind of stuff happens during probate. So often in probate, there's not, more often than not, but frequently there's conflict where, you see people coming out of the woodwork and saying they promised me this, or they just say, whatever's in the will, I don't want to happen, so I'm going to try to contest it. So a lot of people want to avoid probate as a whole. And the way probate works is all of the assets owned by the decedent go through probate. So the goal is, if you do want to avoid probate, to have no assets in your own name when you pass away. You can use things like trusts, you can use things like transfer on death deeds, and properly planning with your financial planners and CPAs to make sure that your assets are properly beneficiary. That life insurance has a primary beneficiary and then contingent ones, God forbid something happens to the primary. Same with retirement accounts and brokerage accounts, and like I said, with just your standard bank account, you can go to your bank and you can say, I want this to be a pay on death account, which then, since it is pay on death, it transfers immediately upon the owner's death. So it doesn't go through probate ultimately. The trust works similarly. The trust is an entity that you create, for example, a revocable probate avoidance living trust is an entity that you create, and then that entity now can own your assets. So, for example, you put your home in your trust, you can put all your assets into your trust with some limitations. And basically, the disposition of those assets happens around the kitchen table rather than in what can be a time-consuming and costly probate proceeding. You also have more control over your assets, where some clients of mine will say, I trust my children, but I don't necessarily want them to inherit large sums at a young age. You can control your assets and say, my children can inherit 1/3 at the age of 25 upon these conditions, graduating from an accredited university, passing a drug test, all those details you can include in the trust. And I always recommend to clients, when you're thinking about all this stuff, to work with an attorney, but also to sort of have a team around you, have a trusted CPA, have a trusted financial planner, have a team of professionals, because there's always perspectives that need to be thought about that maybe I haven't even considered that those professionals bring in. So, again, frequently asked questions. People ask me, what sort of taxes am I going to owe, or is my estate going to owe after I pass away? So the federal estate tax only kicks in if your estate has more than $11 million per an individual and $22 million for a couple. So it affects very few people right now. That could change with changing litigation, but changing legislation. But Virginia has no estate tax per se. They do have a probate tax, county and state probate tax that's around, $1.33 per $1,000, but it generally is not going to be a huge tax. Other states have inheritance taxes. Virginia does not have an inheritance tax. Another frequent question is, am I going to take on the debts of, if, for example, if a spouse comes to me and says that their husband passed away, am I responsible for all of their debts now? The answer is no. Unless, always the lawyer answer, no, unless unless you co-sign. If you jointly sign, of course, you will have joint liability. But just because the person passed away, and let's say you're their sole beneficiary, does not mean that the debt passes on to you. Mortgages are a little different. Mortgages stick with the land, but with very few exceptions, debt does not go past just being a debt owed by the estate. So that sort of gives a broad description of what estate planning tools there are and sort of what their benefits are of having them. So, Jean, any questions about that, or is there any questions coming in?
I have a lot of questions, but so when I start, all you guys watching, if you want to just type in any questions or comments that you have, and we can ask Michael, because I would say, a basic understanding of what he's talking about, and even I have so many questions. So any questions, feel free, throw them at us, just type them in the comments and I'll ask. But so if you heard the little clicking, I was typing my questions since I didn't get a notepad before we started. My first question is, you talked about a will and designating a guardian for children. What happens if you don't do that? If you have children that are minors and you don't designate who's going to take care of them when you pass, what happens?
It would be the subject of a probate proceeding where, guardianship would be the issue before the court, and sort of that would be decided through that proceeding, which a lot of people don't like. That's why it's really important for an issue as important as guardianship to make these plans well in advance. And I also, I always harp on this as well. I always recommend with clients, after you create these documents, to be really open with communication with your family members, because one of the largest causes of conflict is, mismanaged expectations, where some people thought that they would get something or be nominated guardians. It's always good to, after you create these documents, share which decisions you've made, and even share the documents, because then there aren't surprises after you pass away. And I also didn't mention that it's always good to have a standalone nomination of guardian that's identical to the will, but the reason you do a standalone in addition to it is because if you revoke the will, that really important issue of guardianship will still be something you've made clear and will be followed after you're passing away. So
just to follow up, when you say that it's the guardians of the children are determined in probate, what happens? Is there a judge that has a hearing and different people are trying to get guardianship of the children, and then a judge decides? What happens?
So it could be as streamlined as, someone coming forward and being nominated as guardian, or if it's contested, there would be, a custody sort of fight. But yeah, it can look any. Probate is one thing that's really great about probate is that the clerks and judges will work with you really well, especially if there isn't conflict, to sort of get exactly what you want to happen. But if there's conflict, yeah, there's going to be sort of a legal proceeding to determine custody.
Okay. What happens? My questions are kind of all over the place. In your will, you mentioned obviously that you can designate where property is going to go. What happens if not all of your property or assets are listed in there?
That's a great question. So what that would mean is it's an asset not contained. So your will, if it's done appropriately, will have a catch-all. We'll say, if I have not designated, basically the residue, the legal word for it is residue. And it says anything that I haven't specifically designated goes to the residue of the estate, and the residue goes to this person. But let's say it's done with one of those online services or something like that, and for some reason that hasn't been determined. It would be determined, if it wasn't included in the will, by intestacy, which basically means if there isn't a designation by the will, the state decides. Which there's a sort of a setup where assets go where they're supposed to go, determined state by state. In Virginia, if you're married and you only have children by that spouse, 100% will go to your spouse. But often there are blended families or just different situations where the state's sort of set up for intestate succession, and that just intestate just means without a will. It's pretty rigid, and it would go maybe not where you want it to go. Maybe you get lucky and it does, but that's again why it's important to have a professional do it and make sure there's a residue clause so that you have to have a catch-all.
Mm-hmm. When you were talking about the medical, the advanced medical directive, you said that designates somebody that can make medical decisions for you. Could you just go into a little bit more detail about that? At what point, what has to happen to a person to make that medical directive kick in? How serious is a medical issue in which that person would need to start making decisions?
Sure. Again, that's a great question. So to answer that, I'll just speak briefly about the power of attorney. With a power of attorney, again, the one that designates a financial agent, there are a couple ways you can set it up. It can be upon a condition of incapacity. So it can be, if I'm determined by a court or by a physician that I can't make decisions for myself, or powers of attorney can just be, they could just be immediately in effect. So, just if somebody's out of state or out of country, the spouse, if they have a power of attorney that is immediately effective, they could just act as though they were the individual. So I say that to say that advanced medical directives do not work like that. You can't designate your medical decisions to another person while you're still competent. So, the physician is going to be looking to you to make your medical decisions while you are competent and able to make decisions for yourself. But once that situation passes, once you are not able to make decisions for yourself, that's when the advanced medical directive kicks in, based on the language in statute in Virginia and, of course, in the medical directive, which says when I'm no longer, if one physician, or if you want to, you can change that, if two physicians, or if my primary physician and, psychiatrist, if, whoever you want to be weighing in determines you are incapacitated, then the agent under the advanced medical directive can make decisions for you medically.
Okay, so basically it sounds like if you can no longer physically communicate, or you are basically at a point where you're legally incompetent.
Exactly, incapacitated, with memory loss issues or just capacity issues, or of course for example, non-responsive, of course.
Mm-hmm. Well, when you say memory loss issues, how would, if somebody has Alzheimer's or dementia, how does that factor into those decisions?
So the standard answer is capacity can be determined, of course, by a court, where there can be a conservator or a guardian appointed for somebody if they have issues with Alzheimer's or just general competency. But if that hasn't happened, it's sort of vague. You know, everyone who's dealt with it in their families or with their people in their lives knows that people with Alzheimer's can be perfectly lucid and competent one day and certainly not another. So, you know, for example, capacity really goes with that. If they are lucid and able to communicate and are determined to be competent by really whoever's dealing with them, they could be still their own decision maker. But you know, if it's in the alternative, that's when the documents are going to kick in. So that's why it's really important, again, to go back to it, to make sure you've communicated with your agents to advocate for you. Because in those sort of gray areas, it's really important for your advocate to show up and say, here's what they want, here are their decisions. You know, even if you're still able to communicate, your agent is there to advocate for you.
Okay, that makes sense. Sarah actually has a question. She says, as far as beneficiaries and debt, what would happen if the estate, my savings, investments, etc., cannot pay back all of a debt, like a mortgage? Part B to the question, does the whole thing have to be paid on death, or can it still be done monthly?
So I think I'll answer part A first. So part A is saying if your estate can't pay your debts, what happens? So just to keep it round, you know, round numbers, let's say you have a $20,000 Amex bill, but there's only $8,000 in a savings account with the entire estate. That would be what's called an insolvent estate. And it's the executor's job, or if there's no executor, the personal representative, their job to pay the debts, you know, because that's one of the jobs. And if there's any money left over, give it to the beneficiaries. But if it's not, it's called an insolvent estate. And the executor, the creditors can either make a claim against the estate or not if they don't think it's worth their time, if there's not enough money. But again, the critical takeaway that I don't know if this is exactly what Sarah's asking, but critical takeaway is it does not pass on to the beneficiaries. The Amex bill that, you know, Father John Smith has, it doesn't go down to the children. It would just be a debt of the estate, and if the estate is insolvent, then really the creditor is going to be sort of out of luck. The one thing that you'll run into, and this is again, you know, it gets sort of in the weeds, but sometimes there'll be, you know, valuable personal property, but there's not a lot of liquid funds, and there's sort of just an informal passing on of personal property to the descendants. If that is known by a creditor, creditors can make a claim against a beneficiary for improperly handling an estate. You know, so it should have gone through the estate, the probate process. They can make a claim against a beneficiary. So it's important to be really careful and never do things under the table. But as sort of a standard rule, debt doesn't pass on to beneficiaries. However, mortgages stay with the land. So really, it's going to depend on your mortgage contract what sort of things happen when the mortgage holder dies. But most frequently, I've not run into a situation where the mortgage holder has said you need to pay it. But for example, if you couldn't afford it, that'd be a great reason to go ahead and sell the home, you know, and deal with it that way. But you know, the mortgage does go with the land. So if an individual is inheriting it, they inherit that liability, the mortgage. But I haven't run into a scenario where the mortgage company has said, okay, there's a $400,000 mortgage, pay it all at once. I haven't run into that. I don't think that, again, it would depend on your mortgage contract though, because it's really the contract that would determine that.
Okay, so I am not a homeowner, so I have not seen one of these contracts, even though you'd think I would, being a lawyer. When you're buying a house, there is a clause in that contract that would cover such an issue. What happens if the primary person making the payments is deceased or incapacitated or something like that?
Yeah, I mean, it's got to absolutely. I mean, I haven't seen many. I've seen my own, you know, but they're going to be, you know, they're hundreds of pages long mortgage contracts. So there's going to be a provision there because it's got to be the most common issue in the world, you know, a homeowner passing away. And you certainly don't, I haven't run into someone saying, oh my gosh, I just inherited a house and the bank is calling the mortgage. I think it could be possible, but I just haven't run into that.
Sarah's question actually made me think of something based on your response, trying to get rid of assets so that they wouldn't go to the debt. I think I recall from law school in my trust and estates. I don't remember when I was. Never mind. But I recall hearing that if somebody is purposely trying to give away items or assets that are worth a lot of money to avoid this problem, so that their family does not need to pay the debt, so it doesn't go to the estate. Is that the kind of thing that you were talking about? Like, say, for example, I have a lot of jewelry, and then you know, I I just give it to somebody so that it doesn't have to go through the whole probate process. Is that the type of thing you're talking about?
So specifically, if a person, I mean, a person can make any sort of gift they want while they're living. Obviously, there can be tax implications for big gifts, but there's no that wouldn't be fraudulent, transfer or anything like that. If you gave things away because you knew you were going to pass away or something like that, at least not as far as I know. What I'm really talking about is after somebody passes away, the beneficiaries, let's say they go to the house and they find a bunch of sentimental or valuable personal property, and they just take custody of it, antique furniture or, a car collection or whatever it is. And then there are, the $100,000 worth of debt that's claimed against the estate from all sorts of creditors, but there's no liquid cash in bank accounts or retirement accounts or anything. What would happen is the creditors would say, "Where's the money?" And the beneficiaries say, "We don't. It's an insolvent estate." So if the creditors found out that all of that sort of valuable personal property was just sort of taken by the beneficiaries under the table, that could lead to a suit by the creditors against the beneficiaries, saying you improperly handled this estate. All that personal property should have been inventoried and sold to pay the debts of the estate. So.
And is that something that the executor does? The executor is the person who inventories everything.
Yeah. I should have mentioned that. It's one of the most important jobs of the executor is to inventory all the property, pay the debts of the estate, and then give the remainder to the beneficiaries in accordance with either state law, if there's no will, or the will.
Mm-hmm. Now, is the executor usually a family member?
Very frequently, people choose a family member. I always say, it's I live by many mantras. My wife will tell you, I repeat them over and over. But one of the things I always say is, your family best. It should be, it is either clear who in your family would be good at keeping deadlines, dealing with finances, being really organized, because it's a big job. And if that person is not immediately apparent, or if you don't really have someone that you would want to nominate for that, there are ways you could choose a corporate executor, or if it's a trust, a corporate trustee with financial institutions, or there are lawyers who do it and CPAs and financial planners who do it, because it is a challenging job. But really, all you need to do is be organized and meet deadlines and follow the court's orders, that kind of stuff.
Mm-hmm.
But most frequently, especially in my practice, someone generally spouses want each other to be their first option. And then the second option, if it's a number of children, maybe there's the oldest child, or maybe there's one child who's, really organized, and they'll choose that person. But sometimes clients have said, we don't really want to choose a child, so will you connect us with a corporate trustee? And I'll help them find somebody who can handle that.
Okay. And does the executor get paid for the work they do, whether it's a family member or an outside person?
So it's generally a family member doesn't get paid. It's something you can put in your will. A lot of my wills say the executor will serve without compensation, or and the reason you do that is because it's family, and it's just sort of the way things are done, to not charge, as an executor if you're a family member. But some families aren't like that. Again, your family best. So there are words you can put in: reasonable compensation. There's sort of, again, an understanding of what reasonable compensation would be for certain jobs that need to happen with the probate. And certainly if you're using a corporate trustee, there would be a schedule of fees, so there's, Capital One has its own corporate executor and corporate trustee branch, and they have a public schedule of fees that they would follow for certain jobs and what they're serving as. So in my experience, generally family doesn't charge, but they can. They certainly can.
Okay. Oh, another question I wanted to ask. I went back to my notes. What happens if you do not have an advanced healthcare directive? Who makes decisions if you are incompetent physically or mentally?
So it's again one of those gray-ish areas, and why it's so important to have one. But so the answer is, if nobody's there, if there's nobody there to make decisions, it's going to be the medical professionals making the best decisions they can for you. But remembering that the medical community has a lot of considerations with liability. So, of course, your best interests hopefully are the number one thing in the medical professional's mind, but not necessarily your personal wishes. So the answer is, if nobody's there, the medical professionals. Now, often a spouse will be on the team of people making decisions for someone who's incapacitated, but not always. A, they might not be contacted, and B, there are stories, horror stories I've heard where a spouse is told you can't, come back into the, there's medical procedures going on in the back, and you need to stay here and wait until we come get you, and decisions are made without them. Same thing, I forgot to mention as well, I have clients who ask me about doing advanced medical directives, powers of attorney, and HIPAA waivers for their college-age children. So, generally, again, you don't think of an 18 or 20-year-old getting their estate plan together,
Mm-hmm.
but while they may or may not have accumulated a lot of assets, who's going to be, if they're in Richmond and the parents live in Sterling, are they going to be contacted if the child, God forbid, is injured and is going through medical procedures? The answer is maybe. So if you do get these documents together, it's much more likely that you're going to be a part of the decision-making team.
Okay. That's really why I'm asking these questions, because people, I would think that people just don't know. You don't like to talk about it, and then you find yourself in a situation where it's too late. That's why it's too late. So that's why I need to be at least thinking about these things now and be well informed. At least I would think so.
Yeah,
but I don't practice what I preach. Michael, maybe you and I should have conversations like
that. Well,
do as I say, not as I do.
Well, I always say, you never know what's going to happen, but almost all of my clients, when we go through this process, feel good at the end. They feel like there's a weight off their shoulders. They know what's going to happen. A lot of clients and a lot of people say to me, or at least are thinking, and you sort of glean, they don't want to think about this stuff, because if they think about their demise, it's going to happen. But it's just any other dealing with a lawyer. You go through it. You're going to get some documents together. Hopefully, it's an experience where you're going to feel more comfortable at the end. And then, like I said, you go back to living. It's just not, you don't have to worry about this thing. I always will say, to sort of, again, give the lawyer a response, you should generally look at your estate plan every 3 to 5 years to see if there are major changes in legislation, or to see, of course, if personally your life has changed drastically with your finances or with personal relationships, because again, the state has laws that will supersede your, what you want to happen. For example, marriage, divorce, those things drastically change your estate plan, even if you have documents drawn up. And children, having children as well, because there are state mechanisms where spouses and children can take a share, for example, if they're not included in an estate plan, which may be what you want, and it may be not what you want, depending on what you want.
I just thought of 2 questions based on what you just said. If you have a will and documents and everything set up, but then you do end up getting divorced, do the documents that list the former spouse still control? And my other question, I forgot. Why don't we answer that first?
Yeah. So almost all of your documents are going to be changed by getting a final order of divorce. Some documents get changed with, and this is best answered, by a divorce attorney, but based on what filings cause what. But there are documents that get revoked if you file your divorce, not even get a final disposition of your divorce, but then there are documents that get revoked if you do have a final decree of divorce. So it drastically changes it. The example is, of course, advanced medical directive, executors, beneficiaries, even if they're supposed to be a spouse and then you have a divorce, it's not going to be the spouse anymore.
So I guess what I'm asking is, does everybody update their will, or is the will, whatever the document is that no longer valid because of the divorce, or do you have to actively go and change those documents?
It's important to update them. One of my, some of my best business connections are divorce attorneys, because they'll work with their clients and then they say, it's important to update these because, it says your now ex-wife with whom you just had an acrimonious divorce is the one making medical decisions for you if you're incapacitated. You may not want that, which, you can laugh. I think it's, funny, but it's really important too, because it's the most important things that you hope never happen. God forbid things happen, but yeah, you'll need to get them updated certainly after a divorce. Some documents, parts of them may still be valid, and some may not. It all depends on how they're drafted. But certainly, if it says 100% of my estate goes to my wife, comma, Sarah, it's not going to go to Sarah anymore. She'll be basically taken out of the will.
Okay. So it really comes down to how the documents are written in the first place. It plays a big part in this too.
Yes.
Okay. Because you could potentially, in writing those documents, plan for changes later by being very specific in the way that you outline everything, I guess.
Absolutely. Yeah. There'll be parent or grandparent clients of mine who will say, 25% of my estate goes to my son and 25% goes to my daughter-in-law, given that they are still married at the time of our deaths and they have not become estranged, and any sort of other conditions. Or people can say, X% to my son, and if my son predeceases me, to my daughter-in-law, but only if X, Y, Z, because you wouldn't necessarily, you may still, but you wouldn't necessarily want things to go to somebody if they're divorced or no longer taking care of the children with your family children. But yeah, every situation is really different. That's why, I'm always, I always sort of repeat this, if you can, if you're a particularly competent person, you may be able to get by with doing sort of online or sort of form estate planning. You'll certainly save a lot of money if you do that and you don't use an attorney. But there are just so many little details with law and with everyone's specific situation where it really is one of the areas where, and of course, it's a estate planning lawyer saying it, so take it with a grain of salt. But it's important to get a lawyer to look at these types of things before making big decisions. Or even executing them. One of the most frequent issues I see where someone will say, I want you to do my power of attorney. I've already got my will. And I say, totally, absolutely. Do you want me to look at it? And they'll say, oh, okay. And I'll look, and it's, it says, whatever. It won't be signed, or it won't have notaries, or, it has blanks, for where 100% of my estate goes to blank because they were supposed to fill it in. And they didn't. So it's, it's like, okay, well, this isn't worth the paper it's written on. So, you'll need to either finish it or, let me know what you want to do.
Yeah. Sarah actually had another question. She says, how do you align your various account accesses, passwords, and such to support the executor? Oh, that's a good question. Are there standards to securely share in this very digital age? I never even thought about that. Yeah.
So it's, again, stuff that comes up a lot. And what I do, both the will and the power of attorney. So in the will and the power of attorney, both have sections that say, my executor will have control over my digital assets, has, the ability to do whatever is needed to be done with my digital assets and electronic assets and non-intangible assets. So it gives them the power, but Sarah's point, I think, is a really good one. If they don't have a password, what are they going to do? So I always, when I do my estate plan packages for clients, it's in a really nice binder and it's separated really clearly. And, there's always, room. And I say, put a list of phone numbers of all of the bills that you pay every month, of a list of your passwords, as long as it's in a secure place and you're like in a safe or in a safe deposit box, which brings me to another thing I'm going to point out in a second. So within a safe place, but Sarah also might have been asking about, securely sharing things in the digital age. I'm sure there are hopefully secure, things that companies offer where you can put all your passwords into it, and then your executor with maybe a password to that, or upon proof of that they've been nominated, your executor can access the passwords. But it's a great point. I'm sure there are things that more ways that you could be secure about it, but I generally recommend just having it in your estate plan binder and then keep that in a secure place, fireproof, safe. But like I mentioned before, a lot of people put their estate planning documents in their safe deposit box at a post office, or not a post office, at a bank. And it's really important to do one of two things: either make it that a person is someone who can access the safe deposit box with the bank, make sure that you file the documentation, or make them a joint account holder on the bank account that's associated with the safe deposit box. Because if your original will is in your safe deposit box, designated a person, your executor, they can't become executor without getting the will out of the box to be able to get into the box as executor. So there are a lot of issues that come up with that.
Yeah, all this stuff I didn't even think about. Okay, so another question, back to what you had mentioned earlier. You mentioned people signing HIPAA waivers. I don't remember if that was in the power of attorney or advanced medical directive, but I was just wondering if you can tell everybody a little bit more about that. And the reason why I bring that up, medical and mental health documentation is so heavily protected. Even me as an attorney for somebody, I cannot get anything unless they have that client or whoever it is has given me written permission to do that. And a lot of people don't think about that. So you want to maybe talk a little bit more about that, since that's more in your wheelhouse?
Yeah, absolutely. So I include HIPAA waivers within clauses in the power of attorney, in the will, in the power of attorney, and in the advanced medical directive, which, it's a waiver where you're saying my executor or my power of attorney or my advanced medical directive agent will have my permission to access my medical records, to meet with medical professionals on my behalf, to take legal actions based on those records, to make decisions regarding visitation, all sorts of stuff. But then, just to be even more careful about it, because it's a great point that it's such a protected issue. We do a standalone, just it's its own document, a HIPAA waiver that says this document will supersede any agreements I've made with individual institutions, and these people, person or people, can access, and can basically access medical records and all the related stuff. So it's, again, standalone and within the other documents, just in case for some reason you've revoked those other documents and you want to keep the HIPAA waiver, you can still do that.
So the waivers that I have seen, that I've specifically been involved in, allowed access to the facility, would only let us use their document, their template that they already had, because I at one point had tried to draft my own, because there's a lot of fast-moving parts, especially in criminal law. So I drafted it so that I would have it, but some places would not accept that. It had to come from their facility. So does the standalone document that you are talking about cover that, or is that sometimes still an issue?
I've never had any issues. I've never had someone come to me and say they're not accepting it, but it could happen. Another area of law this our firm practices. Not me myself, but my father, the other attorney in this firm, he practices personal injury law, so car accidents and things like that. So we'll always have issues where Inova has its own medical records release and et cetera, et cetera. But is that legal? No. If a HIPAA waiver is put together appropriately and binding, then it doesn't matter what a corporate policy is with a medical institution. It needs to be accepted. Now that's the legal answer, but in reality, if you need decisions to be made quickly, that's going to be an issue where when push comes to shove, you got to be on the decision making team, and if they're saying you haven't done it on our form, sure, you put it on for temporary restraining order or some sort of court action, but is it moot? Has the time passed where it was important? So I haven't had that be an issue, but the way that medical facilities work, it certainly could. I don't think they'd be doing the right thing, and I don't think it would even be supportable for them to say we won't accept your HIPAA waiver. It needs to be ours. But they could say it.
Mm-hmm.
It's sort of like physicians sometimes will ignore an advanced medical directive. All of these people that you're dealing with are just people. So, maybe their own personal view of things is that it's not something they're going to follow. So they may not. They may say, I don't care that this person said they want to be able to pass naturally. I want to, I need to first do no harm and do X, Y, Z. And the other issue is a lot of people confuse the advanced medical directive with the DNR, the do not resuscitate, which they are totally different. Do not resuscitate needs to be signed by a physician. Advanced medical directive certainly does not. So, the do not resuscitate you may even say in your advanced medical directive, I wish to not be resuscitated, but you still would need to do a DNR aside from the advanced medical directive. And so some clients will come to me and they'll say, they didn't follow what I wanted in my advanced medical directive. But that's not necessarily, again, it's all, reality can be different than law, and it is frequently. So, it's important to plan as best you can, but, there always will be sort of areas where the law isn't followed or the documents that are appropriately executed aren't followed.
So, I mean, what are the person who's incapacitated, what are the options if those documents are not being followed by any party, the doctor or anybody else involved? What do you do?
I've never had a client need this, but my guess would be if it's something that is going to be ongoing, you would put it before a court. You would put on an injunction hearing or something like that, where they're not following what needs to be done, and you want a court order or a declaratory judgment or something where the court is going to authorize that this needs to happen. But then it would just turn into, I guess, some sort of claim. But I really don't know. It's never happened. But I'm sure. Well, it's never happened to me. I'm sure it's happened. Period. But often these issues, like I said, will become moot. So people won't pursue necessarily anything because you're not going to get it on that day before a judge necessarily. So yeah, I'm not actually sure.
I guess that's a problem, having an attorney be the interviewer. I think there's too many questions. But I do have a couple more that I want to try to get to if we still have time. So I had heard, I don't know if this is true, I'd heard that when someone passes away, bank accounts are frozen. So anybody else that has access to those can't access the money. Is that correct?
So if a bank account is a joint account,
Right.
A lot of times, let's say somebody who's 80 years old and may have capacity issues has put on their child or their grandchild as a joint account holder on their account. That would mean that upon that person's passing, the older person's passing, the other joint account holder would own 100%, period. No probate, no nothing. It's just like people who own homes, joint tenants with right of survivorship. Immediately upon one of the person's passing, the survivor now owns 100%. So there's often some confusion about, another example is, someone will be on an account with someone who's going to pass away because they're supposed to pay for the funeral and medical costs and that kind of stuff out of that account. And then that person finds out that when the person passes away, they really just own it. So they may not. And that was poor planning if that was the only plan. Because joint accounts, survivor owns 100%. So frozen, I think more likely if it's not a joint account and maybe it's just, a parent who has one child and the child is the 100% beneficiary. So the child goes to the bank and they say, can I have a cashier's check for everything in it? And they say, no. Are you the executor? Has the probate happened? If you haven't done those things, the bank will just say no. So maybe that's what, the example you're talking about, where maybe you're owed the money and it's clear as day. And you could even bring the will that says you're the 100% beneficiary, but they'll just say no. In my experience, if they're just sort of playing fast and loose, maybe they will give it to you. But, if it hasn't gone through the court proceeding, they probably will not turn over the funds.
Okay. That did answer my question. I guess I was kind of confusing two different issues there. So I made a note to myself, debts being paid by the estate. But you may have already answered this earlier when we were talking. If a person, if a person passes away and they still owe on their mortgage, then that mortgage liability just goes to whoever the house goes to. If the house is left to somebody, or if the documents say sell the house and split it XYZ. So I guess that would take care of that. But in terms of other debts, like say there's medical debt, say there's credit card debt, that gets if I understand correctly, the executor pays all of that before anything else. Is that right?
Debts have to be paid before any disbursements happen for beneficiaries.
And then if all the debts are paid and there's nothing, well, so I guess where I'm going with this is if there are certain things in the will that are worth money, like a car or something, and that there's no money, do they sell the car to pay the debt if the car is supposed to go to the son or something like that? What happens there?
So this is, again, one of the areas where reality will be a little different than law. American Express, if they have a $20,000 claim or $100,000 claim against an estate, and there's a $4,000 car, are they going to pursue it? Are they going to, the answer is probably no. And your job is not necessarily as executor to find debts. It's to follow the law, appropriately publicize that there's an estate and that creditors need to make a claim before X number of days, and then pay the legally enforceable debts of the estate. But reality, who knows what's going to happen? If it's a big debt and if it's a small asset, more often than not, probably it doesn't get sold and given to the bank. It probably is, you contact the bank and you say, it's an insolvent estate. I have a 2008 Corolla. Do you want me to sell it? And the bank is like, no. But
Okay. I guess the last question I'll ask, unless anybody has something else, I had heard that recently something in the law had changed regarding taxes on estates in Virginia. Is that a thing? Has that happened?
So the law is always changing. The most recent change is that it went up again. The estate tax, it won't even affect you unless you have now, I think it's 11.4 million each. for each couple member. So 22.8. Don't quote me on that. I need to double check the exact number. But so that's a huge, jump to get over before you're getting affected by federal estate tax. Like I said, Virginia has no state estate tax other than probate tax, which is relatively small. But one thing that's always in the news is that this estate tax threshold, the 22.8 per couple, is going to change when the Tax Cuts and Jobs Act sunsets, because it's a part of that legislation. So when that act sunsets, it depends on who's in power. It depends on what's going on in Washington. Not too far away, it was $1 million. And that affected a lot more people, or 5 million, and that would affect just a ton more people than where it is right now. So that's always changing. That's why one of the many reasons why it's always good to look at your estate plan every few years.
Mm-hmm.
But yeah, there's no big changes in adding something that people would really hate is adding an inheritance tax in Virginia.
Mm-hmm.
Because there are states like Maryland and Pennsylvania where a beneficiary finds out that they're going to get $100,000 and the state takes 22%. So the beneficiary is saying, "This wasn't even my tax. It wasn't even my." So that definitely happens in other states, but not Virginia.
Okay, good to know. Okay, well, unless anyone else has any other questions, I guess we're going to wrap this up, because I could just keep going all day, and Michael, both of us have things to do. So I definitely would like to do some follow-ups if you would be willing to, and maybe we can get a little bit more specific if you would be willing to come back. I think this is very good. And also, I just want to say, if anybody's watching the replay of this, because I will be showing it later, and it will be on my Facebook business page and YouTube page, feel free to type a comment in there. It will notify me and Michael, so Michael can get back to answering your questions. So definitely, if you missed the live broadcast, feel free to type in any questions you have. Michael, is there anything else you want to say before we sign off?
Well, just again, if anyone has questions, feel free to let me know. If I know it, I'm happy to share it. And if I don't know it, I'll do my best to give you a good answer. Yeah, I don't know if my contact information can be put out. I can, or share my card or something, and anyone's free to reach out.
Yeah, we'll put your contact info in the comments, definitely. Okay, Michael. Well, thank you so much. I really appreciate your time and all the information. You have a good weekend.
You too. Thanks again for having me.
Yep. Bye.